Hello, everyone. Welcome to another fabulous webinar presented by Bill Porter. Today, our topic is when a notice of completion on a California private works construction project is valid, why does it matter for my collection rights? I'd like to give a wonderful introduction to Mr. Porter, whose practice encompasses more than 30 years in private, state, and federal construction claims. He has regularly represented contractors, subcontractors, suppliers, developers, and owners in complex multi-party construction litigation. His areas of expertise include construction collections, mechanics liens, stop notices, bond claims, prompt payment remedies, construction contracts, competitive bidding, construction defects, and construction-related labor and employment matters. I'm Ariella Wagner, the founder of SunRay Construction Solutions, a national construction lien and preliminary notice service. And without further ado, I welcome Bill Porter to a fabulous webinar.
Thank you, Ariella. Thank you, all of you who have joined us today. Today, we're going to talk about a notice of completion for California private works construction projects. We're going to talk about when it's valid, when it's not valid, and why it matters to you for your collection rights. So here you see the page. If you have any questions, just follow these instructions and we will answer those at the end. All right, let's talk about what a notice of completion is for the first part of our discussion. What it is, it's a document that's recorded generally by the owner of the property where the construction work was performed, although I've seen them recorded by the direct contractor, the prime contractor, the GC. Anyway, though, what it is it's recorded to let the world know that a project has been completed. And the important thing that it does is that it sets the deadlines for contractors, subcontractors, and suppliers to make their construction claims for payment that they haven't been paid at the end of the project, generally. And what it does, as we'll discuss, is it's an attempt by the owner to speed up the process. And as contractors, subcontractors, and suppliers, you have to be very much attuned to whether there's a notice of completion and the issue of whether the notice of completion is valid or it's invalid. Okay. First of all, is an owner of a California private works project required to record a notice of completion? Now, the answer to this question is that, in fact, there's no requirement, but there are consequences to the owner depending on whether the owner elects to record the notice of completion or not. And those consequences will be very important for contractors, subcontractors, and suppliers, because if they do record it, it speeds up the time, okay? And that's what we're talking about. Why does it matter whether a notice of completion is recorded? Specifically, the recording of the notice of completion sets the deadline for contractors, subcontractors, and suppliers to make claims. Very important among the deadlines is the deadline for such construction collection remedies as the mechanics lien, the stop payment notice, and the payment bond claim, which are very powerful remedies. For example, the mechanics lien allows you to sell the owner's property so that you get paid. The stop payment notice stops money from flowing to the GC, so it's set aside so that you can get paid from that source. And then there's the payment bond claim, which is a bond that's sometimes posted on, usually for private works, larger projects, and pretty much on public works, all projects. Anyway, though, missing the deadline to record your mechanics lien or send your stop payment notice and your payment bond claim means that you miss those deadlines. And then generally all you're left is no remedy at all against the owner of the property. You'll only be able to go against the person you contracted, which may be a contractor or a subcontractor. Anyway, though, this is why the notice of completion is so valid, because it determines the deadline for making your claims. And if you miss it, then you've missed your opportunity. So we've kind of answered it already, but why do owners record notices of completion as opposed to not doing so altogether? Because if they really don't have to do it, why do they do it? And the reason is that when a notice of completion is recorded by the owner, to the extent that it's valid, and we'll talk about that, it speeds up the time. Generally what happens is if there's a notice of completion, subcontractors and suppliers are going to have 30 days to record a mechanics lien, and prime contractors are going to have 60 days. But if they don't record a notice of completion, if owners don't record a notice of completion, then everyone's going to have 90 days to make their claims for mechanics lien, stop payment notices, and payment bond claim is a little bit different, but mechanics liens and stop payment notices. So it speeds up the time, and then what happens is that contractors, subcontractors, and suppliers who aren't paying attention to the process will miss their deadline, and that'll benefit the owner. So they want to speed it up by recording a notice of completion. Now, here's where the problem comes in, and here's where you have to be cautious and pay attention to what's going on, because there are times when a facially valid notice of completion, meaning it's a notice of completion, it was taken to the county recorder, it was recorded, it has the county recorder stamps on it, it looks perfect, it is perfect, it's an official document, but even though it's official, it's not valid. And so this is where the technicality comes in that you have to pay attention to. Yes, there are times when it's not facially valid. Usually, the reason is because the notice of completion wasn't recorded on time. All right? The time for recording a notice of completion is generally 15 days after the total completion of the project. And let me talk about that for a little bit. What happens is that owners record notice of completion and there's still perhaps work to be done, or they record it a little bit too late, beyond the 15 days. And when we're talking about completion of the project, it isn't the completion of just your work, let's say as a subcontractor, or possibly as a supplier who supplied materials used by a contractor or subcontractor. What it is that it's 15 days after total completion of the project. And in order to determine when that is, you have to look at what's being done. There could be the littlest of things that have to be done, which would mean that the project actually isn't complete. All right, so it could be a little bit of landscaping not done, a little bit of painting not done, some plates on the wall like switch plates and plug plates for electricians to do their work, some little thing that's not done. So if the owner records a notice of completion and things aren't done, then the notice of completion, as we'll talk about, is not going to be valid. And that means what it means, and we'll discuss it, is that it means it really doesn't exist in a legal sense. It's as if it never happened. Okay, and I'll tell you this, I find that perhaps close to half of notices of completion are not valid, meaning that for a sub or supplier, instead of 30 days to record your mechanics lien, you're going to have 90 days. And an owner will come to you and say, oh, there's a notice of completion. You're too late. So then we're going to talk about in a moment, what do you do when there's a notice of completion? And really, you don't know if it's valid or not, do you? Okay. What happens when a notice of completion is not valid? I talked about this a little bit a moment ago, but what it means is the deadline for all the claimants defaults to the deadline as if there was no notice of completion recorded, meaning in general that everybody is going to have 90 days to, let's say, record a mechanics lien against the owner's property. But if there was a good notice of completion, a valid one, the subs and suppliers would have 30 days and the owner would have 60 days after a valid notice of completion to record their mechanics lien. So then the question arises, when it's time to make a mechanics lien claim, how do you know if a notice of completion is timely and valid? You're just, let's say, one trade. You may be an electrician, a plumber, a roofer, a concrete guy, a landscaper. You could be any one of the trades. How are you going to know whether other trades have been done in order to meet the requirements for actual completion so that an owner can record a notice of completion within 15 days? The thing is that you're not going to know. You just really won't know, because you're not going to know when all the other trades on the project were completed. You don't hang around a project. You finish your work and move on to the next and back to the office, and life goes on. But you can't be babysitting a project, so you're not going to know whether a notice of completion was recorded within that little 15-day window after completion of the entire project by all trades, you're just simply not going to know, okay? So then the question arises, okay, well, if I don't know if a notice of completion is valid, how do I know if I'm going to have 30 days or 60 days or 90 days to record a mechanics lien, let's say? And then how do you deal with this issue in a practical sense? Here's what I would recommend on this. Now, you can't be certain if the notice of completion is not valid, so I think that the only thing that you can really do is just presume it's not valid, okay? If you record a mechanics lien and it proves later that you're wrong, you can release it. It's an easy thing. It's as easy to release a mechanics lien as it is to record it. But if you miss the deadline, you're dead in the water. So I think that you have to, if you're done with your work, okay, you always have to wait for a lien to be done with your work. And you're concerned about the project ending, or if there's a significant delay, I would say record your mechanics lien rather than miss the deadline. Besides, when you record a mechanics lien, the next step would be a lawsuit. And you don't have to file your lawsuit for 90 days after you record your mechanics lien. There's a 90-day window that you have to try to work things out. And if someone can prove to you in that period of time that your mechanics lien is untimely and not valid, then so be it. But typically what happens is that you file the lawsuit, and then after a lawsuit begins, you have a period that we call discovery. And in that period, you're able to obtain information. You're able to compel information from anybody else involved in the lawsuit. And you can find out when was the last work on the project by getting documents. And if you want to have depositions of people, you can find out through investigation that the court will compel to determine whether or not the notice of completion was valid, whether or not it was in that little window. But if you don't record your lien, then you're just dead in the water, and you won't have any ability to go after the owner and the owner's property, which is extremely valuable, because let's say whoever you contracted with, what if they go out of business? What if they go bankrupt? You have to have another avenue to protect your claims, and as SunRay deals with, and as I deal with it, some of the most valuable ones are the mechanics lien, which really goes against the owner, the stop payment notice, which goes against the direct contractor, and the payment bond claim, which goes against a bond company, but ultimately it goes against the direct contractor, who generally has to defend and indemnify the bond company anyway. But that's kind of getting into the weeds. Anyway, though, you can't assume that a notice of completion is valid. You have to assume that it's not valid, and then just move ahead and see where that leads you. Okay. Question arises, okay, now, I don't want to be too late to record a mechanics lien, because if I'm too late, it's no good. Will I get in trouble if I do it too early? And yes, the answer is yes, you can, but it's pretty easy for you as an individual contractor, subcontractor, or supplier to understand when it's too early, okay? Basically, you have to finish your own work on the project before recording a mechanics lien. And this generally would mean doing all your punch list work. Although we've had some difficult case law in that regard, in particular a recent case where someone was given some extra work that they had to do, and they didn't receive the notice, and they recorded a mechanics lien, and they didn't know that they had to do some extra work. And then what happened is they found out months later, and the judge says, oh, hey, your lien is no good because you weren't done with your work. And this is a court of appeal, so it could go to the Supreme Court. But the contractor said, but I didn't know that the work wasn't completed because I never received the notice that there was additional work to do. So it's a tough case, and that was just a month or two ago. I don't know what's going to happen with that case. It kind of upsets everything. So I guess it's just a reminder that all of these things depend on what a judge is going to decide. So if you do your best to do things right and don't get close to the deadlines and the edges of the law, then you'll do better, and you won't end up in court. But that was an unfortunate court case that came down a few weeks back. We'll see what happens with it. Okay, but anyway, in general, once you finish your work, then you can record your lien. Besides, you have to finish your work to determine the amount you're owed, which goes on your mechanics lien. So it usually works out pretty well. But sometimes someone does it too early, and of course, you can't do it too late either, as we discussed. Another question that arises is, what about punch lists and repairs? Do punch lists extend the date of actual completion, or actually the work under punch lists? So the thing about punch lists, which is a list of things that come as you are finishing off your project, you think you're done perhaps, and then the owner or the GC comes back to you and says, oh, hey, there's this list I have for you of things within the scope of your subcontract generally that you still have to finish doing. So what you have to do is you have to look at a punch list as a bunch of different types of things. Now, if they are for work that is not completed, let's say some of those wall plates weren't put on where the switches are, or some of the landscaping, the sprinkler heads weren't screwed on, or some paint was missed. Now that all is work that is not complete. So doing that work will extend the date of actual completion. But also you find on punch lists things like repairs. Let's say you're a painter and the work was all done, but you have to deliver it in a pristine condition, and some other trade was in there and put a big scratch across your wall. Well, it was completed, and then you're coming in for a repair. So repairs won't extend the date of completion. These things can be important when you're determining whether a notice of completion is valid or not. So you have to look at the components of a punch list. And then you would have to see everybody's punch list, not just your own, because it's when the entire project is completed that's important. And this is why you just can't know these things, and you have to presume that if there's a notice of completion that's presented to you to try to get you to not do a mechanics lien or a stop payment notice, that you just have to assume that it's not valid and just move forward, because you're not going to know for sure at that time. Okay, question. Are there substitutes or alternatives to a notice of completion that I should be aware of? Yeah, there is. There's something called a notice of cessation, which is really important. Generally, a notice of cessation may be filed only after work on the project has stopped for a continuous period of 30 days. So all the work by all trades stops. And usually this happens when the project runs out of money. Now, once that occurs, then a notice of cessation can be recorded at the county recorders, and it'll have the same effect as a notice of completion. But it's important that all work has to stop for a continuous period of 30 days. Now, there's another thing, too, that I don't have on my screen here, and that is there's another substitute that isn't a document at all. But in general, if all work on the project has stopped for a continuous period of 60 days, then that can be deemed to be a completion. Okay, and that would be the type of completion without a notice of completion, which would mean that if all work stops on the project for 60 days, then that is deemed legally to be a completion, and then everyone would have 90 days after that to record a mechanics lien or to send a stop payment notice. And of course, the details of these remedies are the subject of other presentations that I put on from time to time, and maybe we'll be putting on one for SunRay in some months to come. And there's also information on our website, porterlaw.com, where you can find out about a lot of these things. Okay, let's see where we are. As far as the notice of completion goes, are owners required to let potential claimants know that a notice of completion or a notice of cessation has been recorded? And generally, the answer is no, but there's also a specific statute on point. Now, they're not required to let people know, and there's that penalty that we discussed before, where if they don't, then everyone is going to have 90 days after actual completion. Okay, and this can be looked up in the California Civil Code and the general code sections we're talking about. For those of you who want to look up a lot of this stuff, is It's the California Civil Code, and you can just Google that and it'll pop up. And then generally these rules are in section 8180 through 8614. Okay, they're all in that range. It talks about preliminary notices, mechanics liens, stop payment notices, and all that, all these construction claims. But generally, if an owner doesn't let contractors, subcontractors, and suppliers know that there is a notice of completion recorded, then the deadline for everyone to record a mechanics lien, rather than 30 days for subs and suppliers and 60 days for contractors that would otherwise be the case, everyone is going to have 90 days. This is because the way it used to be, and I had a role in drafting this law that I'm talking about now, and the other ones as well, but anyway, though, the way it used to be is that owners would record a notice of completion secretly. They wouldn't tell anybody, and then they just cross their fingers and wait for everybody, subcontractors and suppliers particularly, to miss their 30-day deadline when they didn't even know that the notice of completion was recorded. And it was a terrible thing, and everyone complained about it. So I and a couple other attorneys got together, and we got a sponsor, and I think it was American Subcontractors Association, great outfit of California, and we drafted a law and got it passed, and the governor signed it. And basically, for most commercial projects, if there's a notice of completion and the owner doesn't, within 10 days, let contractors, subcontractors, and suppliers know that there's a notice of completion, then everyone is going to have 90 days after completion to record their mechanics lien. And that is a very valuable thing to subcontractors and suppliers. Now, that particular law, I should add, it doesn't apply to little mom and pop type projects, basically personal residences of less than 5 units. Other than that, though, it's a nice protection for contractors, subcontractors, and suppliers. So I'm going to turn it over to Ariella at SunRay in just a moment, but I did want to say that I hope the information was helpful, and I want to thank SunRay Construction Solutions for the opportunity to speak to you today. And I so much look forward to speaking to you again. And if you want to learn more about me and our law firm here, I would invite you to visit our website, which is porterlaw.com. And you'll see on the website a wealth of information, including many articles for California contractors, subcontractors, and suppliers. So Ariella, I'll turn it over to you. There may be some questions, and I'll be right here. Thanks.
Absolutely. Thank you so much. Such a brilliant job. So yeah, SunRay has an extraordinary online application that helps you secure your lien and bond claim rights. You can enter your notices into the SunRay application within 60 seconds. It's so simple. You put in your first day on the job. We will definitely have more webinars to discuss your preliminary notice deadlines. That will be in 2020. But it takes only 60 seconds to enter in your information, such as your job address, who you have a contract with, if there's a lender on the project. In addition, we have an amazing free, you have the ability to create free reminders in the system. So we were discussing notice of succession, notice of completions. You could set up a reminder in the application for free, so you do not miss these very, very, very crucial deadlines. And another fabulous feature are the waivers and releases, and that's another webinar that we'll be putting on in 2020. You could do all of your waivers and releases for free using the SunRay application. And at this point, we're going to take any questions. If you have any questions, please fill in your questions at the bottom right-hand corner. And so far, we don't have any. And what we'll do is, I know that sometimes people get a little nervous, even though it's a webinar, to ask, but we'll go over right now for the next webinars we have. It's how to recover your legal fees when you collect a debt. That's on November 14th, and that's conducted by Alexander Barthet. And the next webinar after that, December 12th, is Ode 5K or Less, Take Them to Court Yourself. Here's How. And that's going to be on December 12th. Again, if you have any questions, please feel free to send Mr. Porter an email. And you could see his email address right there, bporter@porterlaw.com. Of course, you can always send me an email. And what a fabulous webinar that you did. So thank you so much.
Thank you, Ariella. It was my pleasure.
Okay, I wish everyone a wonderful day.
Bye-bye now.